This podcast is brought to you by the School of Advanced Study, University of London.
Welcome everyone. Pleasure to welcome you all to the Institute of Advanced Legal Studies. My name is Jules, Winterton, Director of the Institute, and this is one of our extensive programme of evening events. Do register on the website if you want to be having notifications of future events. Now, it's my great pleasure to introduce James Michael. Probably needs no introduction to many of you. Senior Research Fellow here at the Institute, formerly of the Faculty of Laws at UCL, our near neighbour up the road, and colleague and friend for many years. And his field of research is, as you might have gathered from the title of the lecture, data protection, freedom of information, privacy, inquiring into it from its early years right up to the important position it holds in all our lives nowadays. And I should say his series of lectures over the years here at the Institute have always been eagerly anticipated and, as you can see, very well attended. And I understand he has some proposals to present this evening, and also some exciting news about the Institute's further engagement in this important area of research. So I'm going to hand over to James, and you have the title of his presentation here. So, James, please.
Okay, thank you very much, Jules. I've been doing this for about 12 years now. Started, I think my first lecture was comparing interception communications under British and American law. Little did I know. But first of all, I'd like to announce that this is part of a kind of soft opening for the Institute's Centre for Law and Information Policy, directed by Jules, who's sitting over there. If you'd like to say something about the full-blown launch on the 24th of February.
Yes, yeah, James kindly allowed me to hijack the floor just to give you a taste of what's to come with the launch of that centre, which and James Michael will be the chair of the advisory board for this new Centre for Law and Information Policy. So on the 24th of February, we've got a two-part launch. In the afternoon, we've got an academic-oriented workshop which will feature a range of sort of leading scholars in the field looking at a variety of information law topics. So if you're interested in that, you can sign up via the IALS website on the events bit. And then in the evening, we've got a speech by Timothy Pitt-Payne, QC, titled "Does Privacy Matter?" And that's sort of a slightly, maybe a wider appeal aimed at practitioners, lawyers, and academics, and whoever would be interested to come. So please also you can find out details of that on the website as well and sign up there. That's all I've got to say. And yeah, check out the IALS website for more details of the centre. Thank you very much.
Thank you very much. Right. This evening's lecture is on the Data Protection Act, 1984, Freedom of Information Act, 2000. And I'm sure that with an audience like this, some of you could probably finish my sentences for me and add footnotes to them. I would rather defer any questions or comments until the end, because I know from previous experience that sometimes the questions and the comments can be, how shall I say, discursive. Okay, this is not going to be a run-through of the cases under the Data Protection Act or the Freedom of Information Act. I will mention some of the cases, but I want to place them in perspective as a way of figuring out where they came from and perhaps what comes next. And so I'll start with data protection and its origins. And Margot will correct my attempt at Dutch pronunciation. The Bevolking Register in Amsterdam, the Population Registry Office. I've referred to this at least one lecture before, but I'm coming back to it tonight because in doing research I've learned some more about it. For one thing, the Population Register included religion. Now, every time there's a census in this country, there's a question of whether religion should be indicated. The purpose in the population registry was for the allocation of the church tax. And church taxes are still a part of the law in many European countries. Sometimes collected by the state, sometimes by the church, sometimes collected by the state and distributed to the church. So, the point is that religion was included in the register for logical, administrative, benign purposes, but it was there. And so when the German invasion came, population identity cards were issued indicating religion, but specifically indicating whether you were Jewish or not. And this was said to be for the purposes of protection. By then, people were a little skeptical of claims like that. And so there was an organization formed underground, De Vrije Kunstenaar, the free artist, and they started manufacturing fake ID cards. And they manufactured about 80,000 of them. Now, the fake ID cards had the J omitted. Now, sometimes this was done by altering the card. Sometimes it was done by losing a card and getting a new card and a new identity. But the authorities began to engage in what we now call data matching. That is to say, they would take the cards and match them against the population register. Because, of course, the register could not be changed, at least not by the underground resistance. And so on the 27th of March, 1943, a group appeared at the population registry office, disguised as, I believe they were guards and workmen, and said they thought there was a gas leak. They went inside, they set their bombs, and data breach with a vengeance. It wasn't completely successful. And from one of the accounts of what happened afterwards, one of the workers arrived to see this, and she said, and I saw people collecting all the cards that were soaked with water to put out the fires and laid them out to dry so that some of the data would be preserved. What happened next? Well, next came a roundup. Geert van der Veen got away for a year before he attempted to break some prisoners out of the Amsterdam jail. He was shot, paralyzed. They took him away, and he was killed, shot. Willem Arandes was captured immediately and was shot in July, and his last words were, let it be known that homosexuals are not cowards. Frida Belinfante, dressed as a man, as was her wont, escaped to Switzerland and spent the rest of her life in Southern California, in Laguna Beach, and she founded and conducted the Orange County Philharmonic Orchestra. And then a year later, more or less, on the 11th of April 44, an RAF squadron finished the job and destroyed the population registry. By then, it was too late. That's the background. And I do not apologize for going back to it, because there is a fundamental transatlantic difference of opinion or of attitude about data protection. Now, I am American, and I'm aware of the right to privacy, if not in the Bill of Rights, at least in the jurisprudence of the Supreme Court. But there is still a fairly widespread attitude in the United States that privacy is a commodity, as well as being a right. But then, as Bob Dylan said, you can sell your privacy, but you can't buy it back. In Europe, the attitude is a little bit different, and partly because of the experience of World War II, various states, countries, and international institutions began to do things about privacy. The land of Hesse was the first to legislate. Why it was first, I do not know. I think that Spiros Simitis might be able to tell me, who was a data protection registrar. The first national statute was in Sweden, which established the first data law, the datalagen, and the experience of Sweden is instructive. And for a lot of you, I know this is old stuff, but first of all, the Swedish expression gave rise to the use of data protection as the term of art, the technical term, rather than privacy. I think, personally, this is unfortunate. It gives rise to a lot of international and transatlantic misunderstanding. Why? Because to a lot of IT people, data protection means data security. That is firewalls, encryption, passwords, biotechnical identifiers, all methods by which data is kept secure from unauthorized access. But data security is not necessarily linked to a person, natural or legal. And I prefer to treat it as a matter for natural persons rather than legal. And so the term data protection, I think, is unfortunate, but we're pretty much stuck with it. Also, the Swedish law established the pattern of regulation. And the pattern had two particular aspects. One was registration. Why registration? Because computers were seen as the problem. And remember, this was 1973. How many of you had a personal computer in 1973? No show of hands. Some of you probably did. It probably filled a room. But the idea of regulating the automatic processing of personal data by requiring everyone who could do it to register their equipment made sense at the time. Although fairly quickly, it stopped making any sense at all. So there was registration, and registration was to be regulated by an independent, more or less, and pretty much more, board. So the pattern of regulation by a process of registration and an independent authority was established as the model. And the model was followed by the Council of Europe Convention. Now, the Council of Europe Convention, this is Convention 108, was published in 1980, opened in 81, and came into effect in 1985. It is open for ratification by non-Council of Europe countries, and I'm almost certain that Uruguay is the only non-Council of Europe country that has signed and ratified it. Why the Council of Europe? Why not what was then the European Economic Community? After all, the main driver, not the only, but the main, was economic. Now, I'm sure there are people in the Council of Europe who would say that they drafted the convention because Article 8 of the European Convention on Human Rights says that everyone has a right to respect the private life, and they perceived a problem under Article 8 presented by automatic processing, so they set to work drafting a convention. But they are also fairly candid that it would not have happened as quickly or as easily if it had not been for the perception that different national data protection laws could operate as non-tariff trade barriers. And if the reason for legislation on an international scale was economic distortion of competition, why not the EEC? The short answer is that the Council of Europe started first with a Committee of Ministers resolution. Notice that there were two resolutions, one for the public sector, one for the private sector. And this was a pattern that was to continue and is still reflected in what's going on with the regulation directive of the European Union right now. That is, different rules for the private sector and the public sector. Whether this was a good idea or not, was simply realpolitik, I leave to your judgment. It may have been that regulation of the private sector was seen as more achievable than regulating the public sector, because regulating the public sector involved data processing of personal information in sensitive areas, law enforcement, national security. In any case, the system of regulation started out as a segregated one. Different rules for different people. Oh yes, on non-tariff trade barriers. This was presented as a problem a lot in the 1970s and 80s. That if different states had different data protection laws, that it would distort competition, there would be non-tariff trade barriers, there would be great problems with the information market. Now, I was a part of quite a bit of that, and there was a lot of speculation. But when the Lindop Committee on Data Protection reported in the UK in 1978, they really could only find evidence of 2 cases, both of them involving Swedish restrictions on the export of personal data to the United Kingdom, actually one of them involved Germany and Siemens, for the purposes of processing, which the Swedish authorities said, you can't do that because that country, the UK for example, does not have adequate protection. So it has to stay in Sweden, which not so coincidentally meant that the contract went to a Swedish company. So the potential was certainly there, but in reality there were not that many cases. But it was a good argument at the time, and it certainly persuaded the Council of Europe to draft the convention, and also countries to legislate. Oh yes, David Weddington, his Toronto speech in 1984. David Weddington was the responsible minister for the British Data Protection Bill. For those of you who were around in 1983, you may remember him. You may remember that the bill was introduced once, and then it lapsed with the general election June 1983, I believe, May 1983, and was then reintroduced. And in committee, David Weddington, we heard me saying quite loudly, I don't see why we're having all this trouble with the National Consumer Council, the National Council for Civil Liberties. There was no problem like this the first time around. Well, that's because the first time around they weren't quite ready. But in his speech in Toronto, notice he only said it in Toronto, if it hadn't been for the economic argument, the British government would never have legislated. I kind of doubt that, but it certainly was a reason to legislate quickly. So, meanwhile, over at the European Union as it became, they started acting about 5 years later with directives in 1995 and 2002, sorry, 1995, 1998 actually. And they had a group of experts as well. They had resolutions as well. They had a draft directive. It took the European, now Union, 5 years between the draft directive and the final directive. So the experience that they're going through now with their draft regulation, draft directive, is actually fairly speedy in comparison. But the directive, of course, was different from the Council of Europe's convention, because the Council of Europe convention established rules, but it did not establish any kind of supervisory body. There was a coordinating committee of state representatives. But if state A, say the United Kingdom, decided to, and I'll give another example which was from a senior civil servant at the time. He was talking about the British delay in ratifying the convention. And he said, some of these countries come in here, sign the treaty, come back in the next day with something scrawled on the back of a fag packet, and ratify it saying that they have adequate legislation. He was referring to Spain, which did sign and ratify, but ratified when they didn't have a law yet, and the ratification was hanging there for several years until they finally got it through the Cortes. But the convention had no arbitral body. There was no court, there was no commission that people, or countries even, could go to and complain that one of the members of the club wasn't obeying the rules. Instead, what they had was the European Court of Human Rights. And if you can, I think there's a, yes, okay. And for quite a few years, people would speculate that if a state signed and ratified the convention, adopted legislation that did not meet the standards of the convention, I don't know, let's be hypothetical and say a complete exemption for anything to do with law enforcement, perhaps there could be a complaint to the European Court of Human Rights saying that the Data Protection Convention was in performance of, in furtherance of the Article 8 right to privacy. Therefore, a failure to meet the standards of the convention was a failure to meet the standards of the Human Rights Convention. Didn't happen. Hasn't really happened ever. If anything, there have been some strange cases like Copeland, which was a case brought to the European Court of Human Rights under the European Convention on Human Rights, in which a woman was arguing successfully that her right to privacy in the context of processing of her personal data, namely her email traffic and her web searches, had been violated. And along the way, she exhausted domestic remedies without even using the Data Protection Act. Why that happened, how it happened, I don't know. But it was an opportunity, and not the only one, for the European Court of Human Rights to say something about the Data Protection Convention. All of which is a way of getting us to the European Union directive and the case law under it. And these are just some of the cases. Lindqvist from Sweden was a case which held that a woman who prepared a parish magazine on her home computer was engaged in processing, and the activity was caught by the directive and Swedish legislation which transposed it. Parliament against the Council of Ministers. This was one in which the Parliament was challenging the Council of Ministers for the agreement with the United States under which airlines were required to provide passenger name record information to the United States. And there had been a transatlantic agreement to this effect. Now, in the end, what happened was that the court said that the agreement was void. Not because it violated any of the principles of data protection. The Advocate General had gone through that whole argument and had said, well, on balance, considering the margin of appreciation, which is more a Strasbourg than a Luxembourg term, the agreement was okay. The court instead said it was void, not because of data protection problems, but simply because it had been brought under the wrong pillar. And at the EU Commission, people said, we'll just do it under the other pillar. And so they did, and so it went into effect. Pro Musicae against Spain was a case in which the question was whether a service provider was required to provide the copyright protection body with the information about subscribers who were suspected of violating copyright. Now, this is a problem that was presented several years ago. It continues. Different countries have come to different, more or less, solutions. France had its own attempt, which is continuing. The United Kingdom has its own attempt. It raises legal problems of privacy and also of enforcement. The case came to the European Court of Justice, and the question was whether it was a violation of the standards of data protection, the Data Protection Directive, for the law to require service providers to disclose the identities of subscribers suspected of violating copyright. And the court said in one of its, I think, less decisive moments, Go figure. It's up to national authorities. That is still working its way out. Whether the predicted flight to countries where they do not require disclosure has happened, is going to happen, remains to be seen. But it's one of the cases in which the directive was enforced. Ireland, more recently, had to do with the legality under data protection, under the directive, of the data protection. Actually, this was whether the data retention directive was legal under the European Union's Charter of Rights. Now, the European Court of Justice, for a long time, said that human rights is a part of European Union law. In many cases, over the decades. They said it because human rights is a part of the tradition of European countries, and then with the Treaty of Nice and now with the Treaty of Lisbon, the notion of human rights as a fundamental part of the European Union starts to get teeth. And the teeth are being used from time to time by the European Court of Justice in judging the compatibility of actions by the European Union institutions with the Charter of Rights. And this is potentially a source of even more litigation to do with data protection and privacy. And then, and these are cases taken not entirely at random, there is the slightly amusing case of Bavarian lager, which went on and on and on for years and years, in which a man was asking to see, and we're into transparency here, was asking under the European Union transparency rules for the identities of EU civil servants and industry representatives who had attended a meeting to do with whether the United Kingdom was in violation of EU competition law in its rules about tied houses. Now, in the event the UK had changed the law on tied houses, the meeting did not really have any particular consequence, but the applicant went on and on. And in the end, the European Court of Justice said, because of the right to privacy, and I'll persist in the US pronunciation, the identity of the participants cannot be disclosed. So, to use the language that I don't really like very much, privacy or privacy trumped transparency in Bavarian lager. Current state of EU law, which you may have been expecting an informed and lengthy analysis of, I won't do that. I will simply say that as of the 19th of December, for the private sector, there is a draft general data protection regulation. Now, for those of you who are not EU lawyers, a regulation means that it will be the same rule for every country. No more national differences. And this is what a lot of industry wanted. At the very least, they wanted to have a single set of rules for all the states in the European Union. And it looks like they're going to get it. What the content is going to be remains to be seen. For the public sector, there will be a directive, a draft directive, that is to say there will be more leeway, margin of appreciation, subsidiarity, or what some Americans would call wiggle room for national authorities and national legislation. I'll return to the Charter of Fundamental Rights, because Article 8 provides the right of protection of personal data, and Article 41 specifically gives a right of access to one's file, what's known as subject access. Now, there is a point here about the Charter of Rights, which deserves some consideration. And that is most of the Charter of Rights, but not all, says that these are standards which must be observed by the institutions of the European Union and by member states when they're implementing European Union law. Now, The Ministry of Justice, anyone here from MOJ? There's been a long series of conferences and meetings about the balance of competence between national and EU institutions. And at one of those meetings, there was a man standing up with a whiteboard and a pen who was asking for comments and contributions and writing them all down so they could be reported back to the plenary session. And he said, now, the Charter of Rights, what do you think this is going to apply to? And I said, well, please, sir, it applies to national actions when they are implementing EU law, and I would predict that in 20 years there will be not many national actions that cannot be characterized as implementing EU law. And he said, I think we won't minute that. The point is that potentially the Charter of Fundamental Rights will give, how should I put this, scope for implementation of privacy rights and also a lot of other rights. Global perspectives on data protection. This goes back a long way to the request by France to the Organization for Economic Cooperation and Development in 1973 that they developed some guidelines. Why was the OECD interested at all in data protection, in privacy? Because they foresaw the development of the information economy. They foresaw the possibility that different national standards could act as non-tariff trade barriers. And they thought that some kind of internationally agreed standards would be a good thing. And of course, they were in favor of privacy, as everybody is in the abstract. In any case, they came up with the guidelines, and Michael Kirby from Australia chaired the party that drafted them. And those guidelines have been influential ever since. Of course, the OECD has no enforcement body. It doesn't have a parliament, it doesn't have a court, all it has is persuasion. But the guidelines were revised in 2013, and I'll come back to them later because I think the role of the OECD is potentially greater than has been realized. The UN General Assembly in December '89 adopted rules for the automatic processing of personal data based on a report by one Louis Joannet, who was a very early official in the French Data Protection Authority who left rather quickly and went off to the UN. Those also were adopted and revised in December. The latest resolution was last December, and it was initiated by Germany and Brazil. And that was initiated after Mr. Snowden went public with his revelations, and Germany in particular thought that the United Nations should do something about it. What they did about it was refer it to the High Commissioner for Human Rights, who produced a report saying there was need for further in-depth study. We will see. Transatlantic disputes, I've already mentioned the passenger name record dispute. SWIFT, for those of you who remember, was the revelation that following 9/11, the United States had been given access to international financial transactions carried out by, well, actually it was a Belgian company with a site in the Netherlands. How did the U.S. get jurisdiction to serve a subpoena on them? They had a mirror site in Manassas, Virginia. And one interesting footnote is that, I'm not sure if this has to do with transparency or not, but it's relatively easy to find out exactly where the site is in Virginia. It is almost impossible to find out where the site is in the Netherlands. In any case, SWIFT had complied with the agreement and had given access to transactions to U.S. Homeland Security people, but it had not said anything to the EU, to the national data protection authorities. In the end, both the PNR case and the SWIFT case were resolved in a kind of truce. Part of the truce is the safe harbor system. The safe harbor system is a system, and this is old stuff to many of you, by which the US Department of Commerce signs up companies who agree to abide by data protection principles that are equivalent to the EU data protection directives. And so, national data protection authorities in European Union countries cannot interfere with disclosure of personal data to those US companies because they are, by contract, adequate in their data protection. But note that data protection is excluded from the Transatlantic Trade and Investment Partnership. Global differences? Of course there are global differences. There is the Asia-Pacific Economic Cooperation cross-border privacy rules. And there is also the Center for Information Policy Leadership and the Accountability Principle, which, and I hope I'm not distorting this here, advocates a system of self-regulation backed up by legal sanctions in the end. I simply mention these. All of these can be gone into in great detail. My point here is that there are differences in data protection privacy standards in Europe, the United States, Asia, and throughout the world. Okay, when is he going to talk about data protection cases? You'll see that the Data Protection Society, which may generally be thought to like data protection, says it is generally accepted that the Data Protection Act was very badly written and in places it's dense and hard work to read. It is not a page turner. Well, tell me about it. Cases, and these are just recent cases. And I simply put them up to ask you to consider if the world would be a better place if this hadn't happened. EMC Advisory, £79,000 fine for nuisance calls. Worldview, $7,500 for data breach of payment card details. QuickFit, $90,000 for nuisance calls. Parklife Manchester, public sector, $70,000 for 70,000 unsolicited marketing texts. Ministry of Justice, so it bites on the public sector sometimes. £180,000 for a serious breach of data protection principles regarding personal data of prisoners. When is he going to get to freedom of information, I hear you wonder. This is it. And I told you this is going to be about perspective and where these things came from. Data protection came from the Council of Europe, came from the European Union. Freedom of information did not come from the Council of Europe, did not come from the European Union, although they're catching up. Instead, it was inspired by national legislation, and in particular, Sweden. I once wrote something about this and started the chapter by saying, why must it always be Sweden? Variously attributed to Keith Joseph, I believe, and Lord Hailsham. Whatever the subject was, Sweden came up with an answer first. And I spent a year in Sweden and tried to find out why Sweden legislated to provide a general public access to government documents in 1766. Conveniently 2 centuries before the United States got round to it. And from my experience in the United States, Americans didn't know anything about it. Well, they did it because of a man named Peter Forsskål, who lived in the 18th century, actually before Jeremy Bentham and his obsession with transparency. And he wrote Tankar om borgerliga friheten, Thoughts on Civil Liberty, articulating offentlighetsprincip, the publicity principle. And I am indebted to my colleague David Goldberg, who is not here tonight, who not only discovered this, but was involved in a new translation, English translation, and tells me that next year, Sweden is going to celebrate the 250th anniversary of their first Freedom of Information Act. Well, good for them. Unfortunately, it was overturned fairly quickly by Gustav III and did not actually go into effect until the beginning of the 19th century. There is a bit of terminology here that is, again, unfortunate. And that is that the Swedish law was called the Freedom of the Press Act. Now, it was and is a part of the Constitution, which is, for transparency advocates, a good thing. But it is called a freedom, which in legal terminology is not such a good thing. Because, and without going into Hofeld too much, freedom implies a correlative duty on the state not to interfere. That is to say, if you have the right, the liberty to freedom of speech, you can say what you like without being put in prison, without being fined. What access to information means is a right. That is, a right of access to government records, for which there is a correlative duty on the government to do something. That is, to give you the records. Now, if this may seem like academic hair splitting, it isn't really, because way back in the 1970s, anyone here from Justice? Justice formed a committee to consider the question of a Freedom of Information Act, and the committee decided that it was a bad thing because it was a misuse of the language. To call something a Freedom of Information Act when it was actually a right of access to information law. And so they thought a law was probably not a good thing. The US kept up the tradition of calling it a Freedom of Information Act, adopted in 1966, when it was a right of access to administrative documents. But that doesn't sound quite as dramatic. Things about the United States law: it was passed, first of all, it's not constitutional. Freedom of information, in the sense of access to government documents, is not part of the First Amendment. The Supreme Court has been asked about it and has said no. So, it's an ordinary law. It can be amended. It has been amended. Mostly it's been amended in ways that would make it more effective, but there's always the possibility that it can be cut back by ordinary legislation, which has been tried from time to time. It started, and this is an illustration of federalism as a laboratory. It started with state laws. State laws, and the first one seems to have been in the state of Louisiana. State laws which established two things. One was a public right of access to government documents, and the second was open meetings, commonly called sunshine laws, all put together in a book called The People's Right to Know, Legal Access to Public Records and Proceedings in 1953. France, being more logical and more precise, adopted their law in the form of an Access to Administrative Documents Act, which was right. And it was a right of access to administrative documents. It had an independent body to oversee and decide on complaints. It had exemptions, fairly broad ones, but all statutes have exemptions. And it was enacted as part of a package drafted primarily by senior civil servants, regulating, improving the relationship of the citizen and the state. And the other half of the package was their data protection law, the same year. So freedom of information is a global movement, a trend, if you will. Wikipedia says there are 95 countries. There is an extensive network of communication from countries all over the world reporting on cases, on bills, on amendments. It's a little difficult to tell exactly which countries, which say they have legislation, have anything that really deserves the term. For example, Zimbabwe's access to information law and protection of privacy is almost exactly the opposite, in effect, of its title. And there are some other countries with laws that are good only in name. In other words, they do not do what the tin says. Article 19, I believe there's someone from Article 19 here, has a Global Rights to Information Index, which it is using to evaluate national laws. Stepping back from this and considering the related subjects, because these are two related subjects. I was going to use a figure of the Janus with two faces, but that's not quite right. Reflecting on transparency and privacy. Bacon said, ipsa scientia potestas est. And actually, it was repeated by Hobbes later. I hadn't realized until I started looking at this that Bacon was actually a secretary to Hobbes. Sorry, other way around. Hobbes was secretary to Bacon for a while. The two subjects of rights of access to government, government transparency, and personal privacy overlap in one very specific sense, and that is subject access. The individual's right to see her records. Now, this can apply to public sector or to private sector or to both. And in legal terms, it is probably a good idea if the right of subject access is the same. In the United States, it was not and it is not. So that if in the United States you submit a claim, a request for disclosure of your records to a government department, they will say, or they should say, is that under the Freedom of Information Act or under the Privacy Act? And when you say, why? What difference does it make? They will say, well, if it's under the Freedom of Information Act, you have a fairly wide right of access, but you don't have any right of correction. If it's under the Privacy Act, your right of access is more limited in terms of the agencies that are subject to it, but you have a right of correction. So that when I applied for disclosure of my records to the Department of Defense and got them, in the end it didn't matter because there was nothing I wanted or felt I should correct. But it could have made a difference. In the UK, when the Freedom of Information Act was passed, this was resolved rather neatly by saying that if there is a request for disclosure, for access to information, and that information relates to the requester, it will be treated as a request under the Data Protection Act. I have absolutely no idea whether there was any connection, but I did, quite a few years ago, write a memorandum for a parliamentary committee pointing this out and suggesting that this might be a solution. I don't know. International law on access to information. It's really deep into resolution numbers and whereas and considering that and recognizing that. General Assembly Resolution 59.1 is frequently cited as the basis for freedom of information laws around the world, and it almost certainly isn't. And I'm indebted to David Goldberg for this, who is writing an article about this, because he points out that 59.1 doesn't say anything about rights of access to anything at all. It is a libertarian resolution saying that freedom of expression, freedom of speech is a good thing without tying it to any sense, any sort of rights of access. Instead, he prefers another General Assembly resolution which goes a little bit in that direction, but not far. Back to liberties and rights, the distinction. The Special Rapporteur on freedom of expression has said twice now that freedom of information in the sense of access to administrative documents is an essential part of the right to freedom of expression under UN human rights law. So, although access to information as a right is not recognized under any of the UN human rights instruments, there is at least persuasive soft law squishy law? An indication of how the law may develop in the special rapporteur, and also the experts on internal justice said maybe the UN should start with freedom of information at home. Because transparency, like privacy, is something that somebody else has a problem with. The world is littered with examples of institutions and countries who are very critical of shortcomings of others without feeling the need to apply the same standards to themselves. Sexual rights to information? Well, the main one is the Aarhus Convention on access to environmental information. Now, the Aarhus Convention has been implemented by regulations in the UK, and it has provoked some interesting case law on the distinction between rights of access to information under Aarhus and rights of access to information under the Freedom of Information Act. I'll simply say that a piecemeal approach to access legislation, like a piecemeal approach to privacy legislation, is not necessarily a good thing, because it can lead to different standards being applied when there is no obvious reason for the difference. Council of Europe, the Committee of Ministers, that is the Council of Europe's executive, adopted a recommendation, capital R, very early on in 1981. I said that the European Convention on Human Rights, we don't have a clock here, do we? The European Convention on Human Rights under Article 10 says that everyone has the right to receive and impart information. Now, does this mean that that right is violated when you ask for information from the government and it says you can't have it? Well, the European Court of Human Rights said in Leander 87, Gaskin 89, Guerra 1998, no. We told you in Leander, we told you in Gaskin, isn't anybody listening? Article 10 assumes a willing provider of information. It does not provide a right of access to government information if the government is not willing. So there. And then along came the Hungarian Civil Liberties Union case in 2009. For those of you who know the case, you know that it falls somewhat short of a ringing declaration of a right of access to information in Article 10. In fact, it falls quite a bit short of a ringing declaration of much of anything. But it does say that a refusal to supply a requested letter, as it happened, violated Article 10. Now, the letter was a letter written by an MP to a court. And so it may have been less than a complete declaration of a right of access to information under Article 10, but the information was being sought by a government body which was a judicial body, and judicial bodies under most national laws are not included. So the court went further than was expected on the facts of the case, even if it went less than was expected on its actual declaration. Oh yes, and along the way it said, Leander, Gaskin, Guerra, times change. And so does the law. And then it came up with a convention on access to documents. Finally, international law is being made in the sense of a convention, a treaty. Now, is this a good treaty? Well, it's better than nothing, although it stops short of saying that compliance should have an independent authority to decide cases. It is fairly flexible and generous in terms of exemptions. Why more countries have not signed up, I don't know. Maybe it's because countries have looked around and have seen things like, well, the UK Freedom of Information Act. And here I must admit that when the UK Freedom of Information Act was about to go into effect in 2005, I did actually write something saying it was better than nothing but only just. I was wrong. Even instruments that are less than ideal can provide a fertile, tempted to use gardening terms, not only better than nothing, but it's very difficult to go back from them. And so the convention for transparency advocates, of which I count myself as one, would be a good thing. The European Union has its own internal regulation on transparency at the European Union, which has produced a lot of case law. They have fairly broad exemptions. They have a two-headed kind of appeal. You can go to the Ombudsman or you can go to the court. And if the Ombudsman makes a recommendation that is not followed, which happens, you can still go to the court. And again, under the Charter of Fundamental Rights, Article 42 says there's a right of access. Now, the right of access to documents under Article 42 of the Charter only applies to EU documents. In other words, this is not a right of access which will apply to nations insofar as they are implementing EU law. No. This is only a right of access to institutions of the European Union. The Organization of American States has resolutions, has principles, and, most important, by far, it has a ruling of the Inter-American Court in the case of Reyes against Chile, saying that a refusal to disclose environmental information on request, this had to do with a logging project, I believe, violates the right to receive and impart information under Article 13 of the American Convention. Oh yes, and the UK Freedom of Information Act, I was going to say something about it. Was it utterly undermining of sensible government? I only give you a few examples. These are actually examples that Christopher Graham chose. Food hygiene inspection, MOT failure, MP's expenses. One point about MP's expenses here, and I'm aware that I'm running over a bit. The disclosure of MP's expenses started as a Freedom of Information Act request, went up the ladder through to the tribunal, and it was in the process of compliance with the order to disclose when information was being redacted that somebody sneaked, blew the whistle, made an unauthorized disclosure, and it went to the Telegraph. Now, I mention that because formal disclosure of documents under systems like the Freedom of Information Act are not the only way that information of interest to the public or in the public interest gets out. Even with the Freedom of Information Act, there is a place for protected disclosures under legislation of that name, which I talked about year before last. And in such cases, there is always a question of whether the disclosure is justified in the public interest. At which point someone, usually a judge, will say, as if for the first time, just because the public are interested does not mean that it is in the public interest. I first read that in the report of the Younger Committee in 1972. But my point is that this observation, that if it's of interest to the public, it's not in the public interest, implies that if the public are interested, then it cannot be in the public interest, which is not the case. I would submit, as judges say, that information about, I'll only say it once, duck ponds, was of interest to the public, and the disclosure was probably justifiable in the public interest. And just reflect on the fact that after the disclosure in the Telegraph, there was a call from some MPs for an inquiry, a leak inquiry, to find the Ponting, the Sarah-Tisdale, whoever it was, and it got precisely nowhere. And consider whether a similar leak, unauthorized disclosure, 15 years ago, would have produced the same reaction. Salaries of public sector employees, private landlords. Finishing up with a modest proposal. Here is my idea. A UN Convention on rights of access to information and to privacy. Now here I'm using terminology which I would prefer in that it's not a freedom of information, but a right of access to information, and it's not data protection, but it's privacy. I know there are other kinds of privacy, privacy in the press, physical privacy, but I would prefer to use the term privacy in the sense of access to personal information and protection of it. Arguments in favor. Well, it would harmonize data protection law, reduce non-tariff trade barriers, harmonize access to information law, because there's a certain amount of forum shopping that does go on in access to information. Now here I am arguing against my own interest because I have engaged in this from time to time. There was a time when I, and later many others, would go to the United States, get information about British companies, about the British government, publish it in the UK, ask the British government department if we could get it here, and be turned down. This went on and on. This was forum shopping. Now the problem with this is that it can amount to leveling down. That is, everybody is just as secretive as everybody else. And it can also impede experiments. Case law before regional courts, regional instruments. So there are arguments on both sides, but on balance, I think it would be, not only do I think it would be a good thing, I think that based on the way the law has developed in the past, that it may be a trend. We will see. I see heads shaking. Negative. Strategy, how will this be achieved? I suggest that the OECD might have a role to play, considering its report last year that this will involve identifying innovative policies and instruments to reinforce the relationship between citizens and their government through greater openness and transparency. Well, the OECD started it more or less with Michael Kirby's chairmanship of the group that drafted the principles. Maybe there's a role for the OECD. Or the United Nations to adopt another General Assembly resolution, referred to the third committee, or to include a convention in their agenda of work. Human Rights Council to establish a working party to prepare a draft convention with NGO participation. The goal to have a treaty open for signature and ratification by January 2025. That's 10 years from now, but that would be lightning speed in international treaty law time. Materials, already gone through the raw material, the General Assembly resolution, the conventions, the directives, the other convention, Charter of Fundamental Rights, Aarhus. There's plenty to work with. Oh yeah. Precedents? Where did I put it? Anyone from Article 19? Article 19 and the American Civil Liberties Union went to the Human Rights Council, actually went to Geneva last March and presented a new capital G, capital C general comment on privacy and said to the Human Rights Committee, you haven't done a general comment on privacy in a long time, and the last time you did it was fairly short. So here's a new one for you. How the Human Rights Committee has reacted to that, I do not know. But it's a precedent for NGO active participation. And also, as some people in the room know, there was active NGO participation in drafting the Convention on the Rights of the Child. What do we call it? Oh yes, who's going to do this? Well, perhaps the Center for Law and Information Policy might have something to say about it. What's it going to look like? There will be a set of principles, an enforceable right of access. There will be exemptions. There will be always exemptions. There will be an independent authority with a right of complaint. And the name, the Convention on Rights to Information and Privacy, or inevitably, there are always acronyms, CRIP, or the Russell Square Convention. Open to questions.
Thank you for your patience. We should have had a bigger room, which is a tribute to the speaker. To say that we've certainly got towards the topic that's going to be addressed on the 24th of February. Does privacy matter? So have a look at coming to that event. And finally, to say a great presentation and setting a challenge to us all, and maybe in particular us here. Thank you very, very much, James.